All right, and I'm back. So let's dive into the first of our topics, which is, does your homeowner's insurance cover you if you defend yourself against an intruder? And the answer is, well, as you might expect from an attorney, the answer is maybe. And it's also worth understanding what we mean by cover you. So typically, owner's insurance is for accidents, for unintentional acts. If you commit some harm or damage intentionally, your homeowner's insurance generally does not cover intentional acts. So you have someone kicking in the front door of your home, a forcible, unlawful intruder into your home. You defend themselves yourself against them. Say you shoot them, they die or suffer some grave injury, and either they're survivors if they're dead, file a wrongful death suit, or if they survive, they file a civil suit against you for damages, arguing that um, your injury of them um, was a civil tort, so a basis for them to collect damages from you, that it was unjustified. And of course, this happens all the time, whether or not your use of force was actually justified or not. They generally don't have anything better to do than file lawsuits against you. In civil court, an attorney can simply take the case on a contingency basis and say, listen, I'll sue this guy. And if I don't get anything, it doesn't cost you anything. And if I do get you money, I keep a third of what I collect or whatever the agreed on percentage is. So it's really only upside for the plaintiff, even though how could he possibly be justified having kicked in somebody's door? But of course, there are arguments they will make. They will make that, oh, sure, our client, the plaintiff, was acting wrongfully, admittedly, but nevertheless, the degree of force, the intensity of force, the nature of force used by the defendant in this civil suit was excessive, unreasonable, and so forth. And often in civil cases, of course, the civil attorneys are not really arguing for a verdict by a jury at the end. They're arguing for a settlement. And sometimes they're just arguing for going away money. Pay them enough money and they'll go away. So in that case, it's not so much the legal merits of their complaint that are controlling. It's, well, how much money are they asking for and how much money would it cost you to actually fight it out in court? Sometimes it's financially prudent to pay the go away money, in which case the guy who kicked in your door and his attorney both walk away with some money in their pocket at your expense. So imagine you do get sued like this. And normally, if someone were injured on your home, you might turn to your homeowner's insurance to cover the civil liability, the monetary expense of that. In fact, normally, your homeowner's insurance will say, hey, we're taking over this case. We're going to pay for your legal defense and we'll pay for the settlement if there is any. But you're not hiring your lawyer to argue this because we're the ones at risk now, at financial risk, the insurance company says. We will appoint our own attorneys to argue this case, negotiate this case, take this case to court, whatever they think is in their best interest, and pay any settlement up to the limits of your insurance that may be agreed to. So all the decision making is in their hands, unless they decide that what happened is outside the scope of their coverage, outside of their contractual insurance obligation to you, in which case they simply wash their hands of the whole thing and say you're on your own. So in this self-defense scenario, there's several ways that this can play out. First of all, your homeowner's insurance almost certainly does not say they cover self-defense scenarios in the home. Almost certainly does not. They tend to be more ambiguous than that. Let me turn off all this beeping that's happening on my computer. The policies tend to be more ambiguous than that because ambiguity tends to favor the insurance company. Clarity often either will discourage people from paying for the policy in the first place if they think too much is being excluded, they're not getting sufficient coverage, or it puts the insurance company too much on the hook, more than they're comfortable with. So they like to leave things ambiguous. Let's face it, they're in the position of power. If something happens and you're getting sued, they decide whether or not they're going to defend against that suit or not. And what will you do if they don't? Well, you have to take them to court yourself. And that's obviously expensive and not something you want to be doing. So what can happen here? Well, the insurance company can say, we're not going to cover you because this was an intentional act. And our policy says we don't cover intentional acts. We only cover unintentional acts. We cover accidents. If you had an accidental discharge, or you had dropped your gun and it went off, or something else unintentional happened, sure, we would cover that. But you didn't unintentionally shoot this guy who kicked down your front door. You shot him intentionally. In fact, it has to have been intentional for it to be self-defense in the first place, right? From both the civil and from the criminal perspective. So if you'd unintentionally shot him while cleaning your gun or something, well, then you might well be looking at a reckless homicide or reckless endangerment charge on the criminal level, which has nothing to do with your homeowner's insurance. That's another point. Your homeowner's insurance does not pay for your criminal defense at all. They simply don't do that. They only cover the civil side of things. If you're looking for coverage against for legal expenses in a criminal prosecution, then you'd have to be looking at something like one of our sponsors. CCW Safe is the sponsor of today's content. May as well put that out there now. They are a legal service membership, what many people mistakenly call self-defense insurance. In effect, they promise to pay their members legal expenses if the member is involved in a use of force event, both for criminal prosecution, which is my focus as an attorney, and also to cover civil liability up to some certain dollar amount. It depends on the level of your plan with them. The criminal liability coverage has no limit. Which is one of the things I really like about CCW Safe. I'm personally a member of CCW Safe. They are by far, of all the competitors in this space, they are by far the best fit for me. My wife is also a member of CCW Safe. Whether they're the best fit for you is something only you can decide, but I do strongly encourage you to at least take a look at what they have to offer at lawofselfdefense.com/CCW Safe. And if you do decide to become a member, you can save 10% off your membership there, using the discount code LOSD10, that's LOSD for Law of Self-Defense, and the number 10 at that URL, lawofselfdefense.com/CCW Safe. So that's how you would have your criminal defense legal expenses covered. On the civil side, your homeowner's insurance may cover it or may not. They may, as I just said, say, hey, we cover unintentional acts, not intentional acts. Then you have to, in effect, sue your insurance company. Or often what will happen is, of course, the person you injured, so you killed them and their family filed a wrongful death suit, or you've injured them and they've suffered some grievous injury they want compensation for in civil court. They generally don't really want to go after you. I mean, you'll be included in the suit, of course, but generally they're going for the deepest pockets, the pockets with the most money in it. And your insurance company probably has more money than you. So what they're really looking for is to go after the insurance company. Also, because the insurance company has more money, they may be more likely to settle without having to go to trial. So whoever you injured is suing you and your insurance company and really wants your insurance company to be on the hook. Your insurance company, if they decide, hey, we don't cover intentional acts, might file a motion for summary judgment in the case with respect to themselves, asking the court to release them as a target of the civil suit, saying, hey, we just don't have any liability here because we don't cover intentional acts. It's right there in our contract with this defendant, which leaves the defendant on the hook for this civil suit and the insurance company free. Well, what can happen then, of course, is that the defendant can sue his insurance company and say, no, you do have to cover me. And of course, the people suing the defender, they also want the insurance company. And so they will also file motions with the court saying, no, this insurance company ought to be held on the hook. So what happens then? The court has to make a decision. Is the insurance company obligated to cover this event or not? And there's a variety of ways that courts come to a decision here. A common way is to say, well, self-defense is an intentional act. The insurance company policy says they don't cover intentional acts. The insurance company is not on the hook for a self-defense shooting. That happens in many, many states. Another way that courts come to this decision is they say, well, self-defense isn't really an intentional act in the sense that the defender didn't bring the event on themselves. They were compelled by the attacker to use force in self-defense against that attacker. And therefore, it's not deemed to be an intentional use of force for purposes of that exclusion within the insurance company contract. So we have a case here that just came out of New Hampshire, was brought to my attention. Let me see if I can share this with all of you. Here it is. So this was these were cross motions for summary judgment. Everybody was arguing about whether or not the insurance company should be on the hook. This involved a homeowner who shot somebody who was in effect invading his home, and the person who had invaded the home now was suing, wanted the insurance company to be on the hook. The insurance company was arguing we should simply be released as a matter of summary judgment. Of course, the defender wanted the insurance company on the hook, and the person who was injured, the aggressor, wanted the insurance company on the hook. So all these parties were arguing it out in this New Hampshire Superior Court, which is a trial court. And in this particular case, the court decided that the insurance company was on the hook. They argued that self-defense, the use of force in self-defense, was not really an intentional act in the context of this exclusionary language in the insurance policy. And I have this order from the court. Obviously, you can see it here on the screen. I'm scrolling too fast to read it. We don't have time to read it in detail in this particular news and Q&A show because I have a hard stop at the top of the hour. But I will embed it for law self-defense members at in the law self-defense blog, where members can access the kind of accentuated form of all the content that we deliver. So all the statutes we reference, the court documents we reference, the articles we reference, they're all embedded or linked or otherwise provided to our law of self-defense members on the law of self-defense blog. So they get that more in-depth understanding of use of force law and all the topics that we cover. By the way, if you're not a law of self-defense member, I would encourage you to consider trying it out. It's really inexpensive. It's only about $0.25 a day to be a law of self-defense member, less than $10 a month. And you can try it out for 2 weeks for just 99 cents, folks. 99 cents for 2 weeks. If you decide you don't like it in that 2 weeks, cancel. We'll give you back 200% of your money. It's a negative risk opportunity. You really can't lose. And frankly, nobody decides not to be a member. Sign up for 2 weeks for 99 cents. If you stay a member, it's again less than $10 a month after that. So not very expensive for what you get. In any case, again, you can try it out for just 99 cents at lawofselfdefense.com/trial. So this particular trial court said, no, the insurance company's on the hook. We're going to make them defend their client against the civil suit by this aggressor in this case. Here's the thing, though. This was a trial court order, and that's binding only on the parties in this particular case. It's not a general rule of law that will apply more broadly, even just within New Hampshire, even just within this court. This court could make a different conclusion in a different case involving different parties tomorrow. Because what happens at the trial court level doesn't have precedential value. It's not controlling on other courts. This is not like an appellate court decision, which creates what we call case law that is controlling on the court subordinate to it, or a state Supreme Court case that is controlling on every other court within the state. This has no precedential value. So the fact that this court did this in New Hampshire doesn't mean that this will be the rule in any court in any other state, or even any court elsewhere in New Hampshire, or even this court with this judge in a different case. So the benefit of sharing this particular order with all of you is that it does a very good job of stepping through the various approaches that different courts in different jurisdictions have taken to this question. How do we deal with whether or not a homeowner's insurance policy is obligated to cover the client of the insurance company in the case of self-defense? And it steps through a variety of cases from different states that come to a variety of different conclusions and methods. Some say yes, they're covered. Some say no, they're not. They have different rationales for arriving at those conclusions, but it gives a very broad view of how all this homeowners insurance kind of stuff works.